Maybe I beg to mention for listing of a case, my lord, quantum case. Maybe 7, my lord.
Quantum case of which year?
Quantum case is 2 and 20.
Next week you have already given date. They have it on 14th.
14. Oblique.
Here pleases your lordship. I beg to mention with petition number 2114/23. Your lordship, the last posting was 4/5/2023. Your lordship, there is one urgency because online examination date has been announced. Your lordship, so kindly matter may take tomorrow. Your lordship, matter has listed for order. Your lordship.
Examination matter, not tomorrow.
Examination.
Tomorrow is Thursday, day after tomorrow.
Yes, your lordship.
May I, Your Lordship, I am paying for listing one matter for orders, my lord. Your Lordship, convening of
Which year? Matter of which year?
21.
21. 14.
And another prayer, item number 56. On several occasions, this matter have listed but not reached. Can it be taken on to Act 2?
Sorry. No obligation.
With please, your lordship, I beg to pay this matter for listing for motion, lordship.
Have you filed?
Yes, lordship.
When did you file?
Today it's a lordship.
You have not filed, you are filing, that means. Is there any urgency?
Yes, lordship.
What is the urgency?
In the similar matter, lordship, your honorable court passed the direction for issue of percentage as the petitioners were without salary from last 33 years, lordship.
There is no urgency. What is the urgency? That tomorrow it has to be taken up.
Lordship,
It will come up in a due course, file it, maybe Monday it will come. No need of mentioning. Yes, next.
Lordship, 21 matter for admission listed many times not reached. Lordship, any date, lordship.
My
Lord, I beg to mention this matter for listing, my lord, next week, my lord.
What matter of which year?
2022, my lord. On May 22, it has been listed. Thereafter, not listed.
Okay, on 16th of June.
May please, your lordship. 2022 matter, lordship, in the admission column, lordship. Matter relates to termination from the post of headmaster, lordship, and
Okay, 16.
May I please, your lordship? Lordship, I beg to mention one writ petition for withdrawal, lordship. Can it come up on Friday, lordship?
Good, really.
Like,
Hey, please, your lordship. Lordship, I beg to mention today's list, order 68, item number 68, lordship.
Yes.
It has been shown as orders, lordship. It's a fresh matter. It should be listed for motion. That may be taken.
Yeah, there is some direction from the registry. We have to clarify that all contempt matters are to be listed in order column. We'll clarify after clarification.
May I please, your lordship? Lordship, item numbers 12, 13, 14, 15, and 27 of today's date. Lordship, we have assessed certain provisions of the Provincialization Act of 2017. Lordship, similar matters are pending with the division bench. It's a rule challenge, lordship. Matter may be listed before the appropriate.
Number Lily.
12. Oblige, lordship.
May I
One
please,
second,
Your
one.
Lordship?
Let us pass the order, Mr. Counsel. We are not supposed to pass the order. Automatically go. Have some patience. What is your name?
A. Chakraborty.
A?
A. Chakraborty.
You are not there here.
Lordship, I am appearing on behalf of Mr. Yukan.
Shri A. Chakraborty, learned counsel appearing on instructions of Sri UK Nair, senior counsel for the petitioners, submit that in these writ petitions, the virus of an act is put to challenge. He further submits that similar challenge is pending consideration before the Honorable Division Bench, being
2447 of 2022.
WPC 244
7 of 2022.
2447 of
2022.
2022. Raised to verify and list these matters before the appropriate bench. Oh, it will take Malili submit. One order, no?
Oblige.
Please give the numbers again. 12,
12, 13, 14, 15, and 27.
no.
Oblige, sir.
May I please, Your Lordship?
Yes.
I beg to mention for listing of QWPC of 2021 for admission. Matter relates to provincialization of service of teachers. Lordship,
We'll have it on 16th of June.
oblige.
May it please your lordship. Earlier matter was listed before this court and left over. Matter was very urgency, provincialization of service, kindly leave the matter, my lordship.
What is the urgency?
Petitioner service was not provincialized.
There's no urgency. Urgency is something is what is the meaning of urgency? If orders are not passed, somebody is going to die over. 16. When was it last listed?
15/5.
15/5.
15/5 was last posted.
23.
15/5 2023.
Don't make a mention.
Left out, my lordship.
Hmm?
That day matter was not
Okay, 16th of June.
May I please, Lordship? Lordship, item number 60
Hmm.
is a application for stay vacating.
Yes.
Only it is listed in the order column. It is supposed to be listed in the stay vacating column. So it can be taken in the stay vacating column. Lord.
Inform the other side, we'll have it.
I'll,
I is by you.
yes, I am the applicant.
May I please your
Inform
lordship?
the other side, we'll have it under the that column.
May I please your lordship? Lordship, item 44, 45, and 46. I beg to mention. Second concern the other side. My senior, Mr. S.K. sir, is out of session due to his sister-in-law's death ceremony.
Is it okay? Have you informed the other side?
Yes.
We'll have it after 2 weeks.
That may be fixed on 9 June.
Either 7th or 9th. I had a discussion with him, my lord.
9 June.
In June.
9 June.
A prayer for adjournment has been made on behalf of Sri S.K. Methi, the Learned Training Council, for CGC,
Oh, my lords. AG.
for
AG. Accountant General.
for AG. Okay. AG. Support para as agreed to by the parties. List on 9th of
June.
Next Friday. Okay, 9 June.
May I please slot
Take order. 44, 45.
May I please note item number 57. Beg to mention that today adjourn the matter kindly. My senior is out of station because of mother illness.
Who is your senior?
AAG1.
Yes, secondary education. Anybody? Who's there? Secondary education? 57. There is an IA for what? Same petition. I is by somebody else. What is the IA for? Aminul Haq. Who's appearing? MU Ahmed. F. Haq. Have you taken their consent? Who's appearing for Aminul Haq? You are with MU Ahmed. You have to take his consent. Then you make a mention. Without informing and without consent, we are not going to allow mention. Yes.
Lordship, this contempt case, my lord, listed on 19, motion, my lord, but listed on orders following. So may I pray for listing a date, my lord, motion, my lord.
Is there or not? Not there today. Is it listed today?
No.
We'll have it on Monday next.
May I please your lordship? May I pray for a listing this matter, my family concern matter.
Motion matter.
Not motion, my lord. Technical matter.
Family pension. Okay, we'll have this on 7th of June.
Obliged. Deeply obliged.
I have actually mentioned item number 65 and 66
Hmm.
in the supplementary.
Supplementary.
I have taken concern of the petitioners, madam.
Hmm.
I have to file affidavit, madam. I could not file affidavit, madam. Next week, madam, your lordship, I'll file. I have sent a copy, madam, but they have not returned back.
You are for the Dimasa.
Divorce. Any day next week, madam.
Okay. On a prayer made by the Learned Training Council, the Mahasab, the matter stands adjourned by 2 weeks.
No, next week, madam. No, yes, petitioner has some urgency, madam. Next week, date will fix, madam.
Matter stands adjourned to be listed on 9th of June. 9th is okay. Or have it on 12th of June to enable the council CIL to file affidavit of opposition.
Another parameter is the listing mallet, contempt case mallet. The contempt in terms of list. Next week mallet, immediate
Which year?
22 mallet.
22. Not next week. We'll have it on 14th of June.
Diploma.
These two matters may be posted for admission last week, for admission regarding provincialization.
We'll have it on 16th.
May it please, your lordship. Lordship, I am paying for listing one admission matter, lordship. Matter
Admission.
related to compassionate appointment, lordship.
Compassion appointment. Matter of which year?
Next week, any date, lordship.
Matter of which year?
22, lordship.
Compassion appointment 14th of June.
Lordship,
14 June.
lordship, if possible 13, 14 M Khan is not available, lordship.
Not 13. Tuesday, then 15th.
Obliged, lordship. Obliged.
My lord, in this case, last occasion lordship was asked the government to take instruction lordship regarding the consideration of the interim order. Lordship.
No, we have received the detailed parawise comment, my lord. We like to file our affidavit within a week.
My lord, with all respect, lordship, in the meantime, they are making process to consider others upon. Only that part, lordship, we want protection, whatever affidavit they file.
What is the protection you are seeking?
Lordship, not to make any further appointment to the post of tutor in Hailakandi district without considering our case, lordship, because they will fully fill up the entire, already 302 appointments they made, lordship. And now they are on process of releasing the salary of that 300. We are not against that, but not to make any, I pray with all respect, lordship, not to make any further appointment without considering our case. That part may be kindly
Lordship will
consider.
see para 14 of their repetition, my lord, their grievance, my lord.
What is your instructions?
For the detailed parawise just now, my lord.
So we are supposed to consider the prayer for interim order today. What have you said? What is your case, Mr. Mazumdar?
Lordship, in this case, lordship, what has happened, lordship? Some irregular and illegal teachers list was prepared after verification. And they appointed lordship 302 by pick and choose basis without considering our case. We are from same footing, lordship. Then we, accordingly, they appointed them as a tutor. We are not against that. We should have to get the appointment, lordship, because we are also now going to be overage, lordship, some of them, lordship. And accordingly, this honorable court, lordship, asked them to issue the notice to them, lordship. And
What is the interim release?
we want that, my lord, only on that, lordship, not to make any further appointment, lordship. They are on process. We have instruction on that, lordship. Process to consider others appointment without considering our.
Are you making, is there a
We don't have any
contemplation?
instruction as such, my lord.
No contemplation.
That observation may kindly.
Okay, well, we grant you some time,
Well,
but don't go ahead. If you go ahead, you will have to consider the cases of the petition.
Yes.
We'll balance
That
it.
observation maybe, so that we may also get.
Madam, you are for whom?
She is for. Item number
Similarly
3.
situated. Three,
Three is also same footing, lordship.
same footing. But 3 against 2 is not proper.
Lordship.
It's not fair.
Lordship.
He doesn't look like a very strong person. 3 against 1, is it fair?
hello?
3 against you alone, fair.
Not fair, my lord.
think Mr. Sissi-
I took him.
This sister will have to get up.
Yes.
With all respect, lordship, we are not against anybody. We want to just get our job, lordship, as a tutor.
Okay. The last order was passed in all these cases, the 3 cases, right? This court wide order dated 25/5/2023, while adjourning the matter on the prayer made on behalf of the department to obtain instructions, an observation was made that the interim prayer would be considered today. Puts up. 3 B. Kaushik, Learned Training Council, Elementary Education Department, submits that the detailed instructions have been obtained on the basis of which he prays for time to fight the affidavit in opposition. On the other hand, learned counsel for the petitioners, namely Sri K. Mazumdar and MS Goswami, G. Goswami, learned counsel, has submitted that already 302 numbers of tutors have been appointed. 302 numbers of candidates have been appointed as tutors, and there is a further apprehension. And there is an apprehension of further appointment by depriving the petitioner. Balancing the equities and in the interest of justice, while this court grants 2 weeks is enough for you or 3 weeks? 3 weeks time. 3 weeks to the department to file the affidavit in opposition, till the next date fixed. It is directed that in the event consideration is made for further appointment to the post of tutors, the cases of the petition in the Hailakandi district, the cases of the petitioners are also liable to be considered along with civil disputed persons. The continuation or otherwise of the interim order will, however, depend on the stand after consideration of the stand or stand of the department that would be reflected in the affidavit.
Lordship, that
List on
after vacation, Lordship, any days subject to convenience, Lordship.
3 weeks we have said.
Lordship.
After 3 weeks vacation will start.
Lordship, I pray, Lordship, it may be on 17 or July, last week of July, Lordship, it may be. Any day, Lord, subject to convenience, Lordship. In the meantime, I'll under peacefully file his.
1, 2, 3. Now we are 3 weeks will end the 21st. We'll have it on 23rd of June. 23rd June.
So we also need to file our reply on that.
If we think that you require time, we'll grant you
Lordship,
time.
please. March of life, Lordship.
Lordship,
High level.
22nd possible?
21st,
Apply.
Wednesday,
March of life, Lordship.
21st.
Thank you.
May I please, Your Lordship?
Yes, yes.
My lord, in this case, my lord, the issue is that the retired headmaster, my lord, has been appointed coordinator by NEOS, my lord. Kindly see place, my lord, 25. 25, my lord. Below down, my lord. Mr. Abu Taleb, principal, is appointed as coordinator of your school institution. The coordinator, Mr. Abu Taleb.
They have filed the additional affidavit.
For my lord.
You are contending that since you are the principal of the school
My lord.
at the time of accreditation, you should be given the.
No, my lord. Then actually I was not. I was PSC different. But he is retired. Kindly see page, my lord, 19.
No, aren't you the headmaster?
I am now headmaster.
Not now, at the time of filing.
No. At the time of filing, yes, my lord. At the time of
You are the
filing, my
headmaster.
lord, I am the headmaster.
You are basing your claim that as per the policy,
My lord.
the principal or head of the institution should be given the made the head of the center and ignoring your overlooking your claim, a retired principal has been given charge.
My lord.
That is your case. Yes, what you, who is appearing for?
And he's still, my lord, account in his name in the bank. He is operating, my lord, through that assistant teacher, my lord, assistant coordinator.
Anybody appearing for NIOS?
MS Arbora appears.
Arbora. Can you, is her name shown in the call list?
SC NIOS has been.
SC there. You know Madam Arbora?
Ranubora. CPS India.
You try to inform her, we'll take up your case after some time.
May I please, Lord? Matter relating to reconstitution of SMC or SMDC, my lord, of a high school, my lord. My lord, the headmaster of the school, my lord, forward the name of the petitioner for the post of vice president in the panel list, my lord, page number 21. My
You're supposed to have the instructions.
lord.
No, even petitioner. Yes, yes. First, anything? Now it is by the deputy commissioner.
Yes, it is by the deputy commissioner. With the approval of the guardian minister, and the names were approved by the guardian minister, the president and the vice president.
The names should be selected by the deputy commissioner from the panel list, my lord. The respondent, private respondent here forwarded for the post of president, my lord. He was selected as vice president, ignoring all the name of vice president.
That is the discretion of the deputy commissioner.
Yeah.
We can admit your challenge, but there is
And
no.
my lord, we have filed an application also, my lord, page number 22, my lord, before the deputy commissioner.
Yes.
That was not considered. Till date.
We will say pendency shall not be a bar for consideration. We will examine this. Since the procedure has changed and you have not challenged the state notification by which the procedure has changed, will
That
you
of
should
the
notice. You are
HM.
H.A. Ahmed, Hartry H.A. Ahmed, learned counsel, was the petitioner who has put to challenge an order dated 6/4/2023 passed by the Inspector of Schools in charge, Borpeta District Circle, whereby the respondent number 6 has been nominated as the vice president of the school management and development committee within bracket assembly of the EDS High School in the district of Borpeta. The petitioner contends that in the panel of names, the name of the respondent number 6 was not there. Correct?
Not for vice president.
Was not there for for consideration to the post of vice president. On the other hand, pursuant to the earlier order of this court dated 10/5/2023, by which instructions were directed to be obtained, 3B Kaushik, the Training Council, Elementary Education Department, has submitted that under the present that at present, the procedure is as per a notification dated 27/10/2021, by which the selection is made by the concerned deputy commissioner, which has to be approved by the guardian minister, which, and in this case, the state procedure has been followed. Para Sri Sarkar, Sri Ahmed, the learned counsel for the petitioner, has also submitted that a representation has been filed, has been filed before the Deputy Commissioner Borpeta on 27/3/2023, which has not been considered. Para issue notice returnable by 4 B Caustic, the learned training council. Elementary education department. Or is high school?
High school. High school.
Secondary
Yes,
education
secondary.
department. Accept
1,
notice
2, and 3 million.
on behalf of responsibles 1,
2 and
2, and 3. 3 Bukolia, the learned state council for respondable 4. Let extra copies of the replication be served on the learned council by tomorrow. That steps be taken for service of notice upon the responsible 5 and 6 of a registered post-dating. Pendency shall not be a bar for consideration of the representation dated 27/3/2023 by the Deputy Commissioner Borpeta, which has been stated to have been submitted by the petitioner.
Right.
Yes.
Matter relates to promotion of grade 4 employee to grade 3 vacant post LD. Petitioner has been serving for 25 years and without promotion. And there in the state school, there is a LD vacant post also. And the petitioner has been presenting many times representation before the concerned authority, but all these are being pending. And petitioner has been also educationally qualified to be promoted to the state vacant post.
So what is the scope of promotion from a junior assistant? You are serving as what? Grade 4.
Grade 4.
What is the scope of promotion from a grade 4 post to the post of LDA?
Yes, Lord. Rules 2003. There is no any provision for promoting of grade 4 employee to grade 3 any vacant post. It's clear cut. But in this concern, there was a earlier judgment passed by this honorable court directing the respondent authority to prepare some rules on the basis to prepare some rules by which senior basis grade 4 employee can be promoted. In addition, if there will be no any seniority basis list of grade 4 employee, then in addition, direct recruitment process will be entertained for filling up the vacant post. So I would like to draw your kind attention with regard to WBC Annexer 8,
Yes.
page 33 to 56.
You come to 25, paragraph 25,
Yes, Lord.
page 55.
In the judgment, para 22. Can I read?
Yes, sir.
In Rule 4A, clause Roman 1 of the 2003 rule, there is a reference to blacklist to be prepared by the school selection
No,
committee.
those are the background observation. You come to the direction at 25.
Direction. Yes, Lord. See, please have a look at para 25.
Yes.
Of page 55.
Yes.
Can I read?
Please read.
Mr. Goswami is right in submitting that though the government was alive to the need to provide promotional avenue to class 4 employees, The same, however, did not materialize in the 2003 rule. In the present fact and circumstance, we are the considered opinion that it will be in the interest of justice to mold the relief by directing the respondent to consider framing suitable provisions for promotion of class 4 employees to the post of junior assistant by prescribing such eligibility criteria as it may deem appropriate. In addition, to fill up the post of junior assistant by way of direct recruitment within a period of 6 months. So I can analyze about this para. We are of the considered opinion. We are of the considered opinion. The court was of the considered opinion, directing the respondent to frame a suitable rule so that
Has any such rules been provided now?
yes, Lordship,
Has the rules been changed or amended in pursuance to such direction?
still have not been.
So in the existing scenario, in absence of any statutory back, how can your case be considered? Under what provision?
Pardon, Lordship.
If the rules are not amended, you don't have a statutory backing for your prayer. How can your prayer be considered now? Unless we have to go by the rules.
Yes, yes.
There is an observation that a consideration can be made for making suitable amendments in the rule.
Yes.
Those amendments have not been done till now. That is an admitted position.
Yes.
Now, under the existing rules, can your prayer be entertained?
The existing rules is Assam Secondary School Provincial Service Rule 2003. There is clear cut that there is not direct mention about regarding grade 4 employee to be permitted to any vacant grade 3 post. But it is a fair according to the different paras of this judgment, and the Superior Court has the jurisdiction to pass any such direction to the
No,
authority.
see, a division bench has said that you consider framing of suitable provisions.
Yes.
Now that that is yet to be materialized. No provisions have been incorporated in the rules for such consideration of such promotion till now.
Yes.
If your case would have been that pursuant to this direction, there has been some change. In spite of that, your case has not been considered. Then we directly entertain and pass orders. But here, you don't have a basis. We can at best issue notice. Mr. Kaushik, what is the stage? Have you made any, applied your mind to this part?
After the 2003 rules, 2018 is 24. Here also, the junior assistant has been made as a direct recruitment post. There's a promotion of junior assistant to senior assistant under the 2018.
No, that is junior to senior. That is the three.
Yes.
And that's a different thing.
Yes.
But
And
what
for
about grade 4?
For grade 4, rule 5, it says recruitment to the cadre of junior assistant and library assistant shall be made by the direct recruitment. So in this 2018 rules also, there is no promotional avenue.
Why don't you apply for the direct recruitment?
Already I have been serving there, and my age is right now 54. Only 8 years in hand to be retired.
No, in the meantime, whenever there was a selection process, why didn't you participate when you were eligible?
I have been already regularized appointed grade 4 employee.
You're a grade 4. You want to
By age I'm not eligible to apply for. Because
right now you say that you are overaged.
Overage.
But from your date of entry into grade 4 till now, there had been some selection process.
No any appointment has been declared. No any appointment has been
In grade 3.
Yes.
In grade 3 post.
Yes.
Then how will you get any benefit? Even if we say that you consider for promotion, if there is no vacancy.
There is a vacancy. Vacancy tank is shown by the school headmaster and submitted before the concerned, that is Inspector School Jorhat District Circle. But on the base of the vacancy tank, they should prepare a seniority basis grade 4 employee submitted before the concerned authority to be promoted whether there is any.
Is there any promotion? That is what we are asking. There is no rules in the. There is no
rules all entered
regarding promotion. What is your name? Your name?
Arkidas.
Archie Arkidas, Learned Counsel for the petitioner by means of this application has paid for a direction for consideration of the case of the petitioner who is serving as a grade 4 employee within bracket beyond in the Hokot Pamua High School under the Jorhat District Circle. The petitioner claims to be serving for about 25 years and for promotion to the post of Junior Assistant Public LDA. The petitioner claims to have been serving in the aforesaid capacity of grade 4 for the past 25 years. To thus, the Learned Council has, however, fairly submitted that the issue regarding the provisions in the rule was considered by the Honorable Revision Bench in WPC in a number of cases, including WPC 997/2016, which were disposed of by order dated 11/9/2019 in the penultimate part of the judgment, the aforesaid directions have been made. Page 55, para 25 quote. It is the case of the petitioner that in spite of such directions, the case of the petitioner has not been considered. On the other hand, Sri B. Kaushik, the Learned Standing Council, Secondary Education Department, submits that the aforesaid direction was considered, and in fact, the rules of 2003 was replaced by a new set of rules, being rules of 2018. So even in the new rules, the post of grade 3 are on the basis of direct recruitment. He further submits that the records does not substantiate that at any earlier point of time, the petitioner had applied for a direct recruitment. Be that as it may, issue notice returnable by 4 weeks. Sri B. Kaushik, Learned Standing Council, Secondary Education Department,
1, 2, 3.
accept notice on behalf of responsibles 1, 2, and 3. Let extra copies of the petition be served upon him by tomorrow. Let steps be taken for service of notice upon the response numbers 4 and 5 by registered post utility served by tomorrow. Please give the names of the act. In a script. Right. 2003 and 2008. Still write it.
Assam Secondary Education Provincial School Service Rules 2018.
And the 13?
And the
2003?
2003 same, 2003. Only
Same.
year will be 2003.
Okay.
Yes, yes, but before addressing the issue your lordship has stated in the last order, only two facts, my lord. 1985, this Mohendra Narayan Chaudhary Balika Vidyapit Nursery was provincial. The year 2006, because there was a shortage, I was appointed as a grade 4 employee by the school managing committee. Now 17 years have passed and I have been continuously voting. I have connect documents included. Now the school managing committee adopts a resolution directing the headmistress to regular do something to act or regularize. The headmistress writes to the inspector and the inspector is sitting over it. I have preferred the representation also. Now the issue your lordship has stated in the last order matter, I'd like to take a short one para judgment.
See, we cannot pass a direction
Yes, ma'am.
in conflict with the rule.
No, madam. This order is not.
We'll say whenever the matter is filled up, post is filled up, you'd be allowed to participate and your experience would be taken into consideration. That's all we can
That is
say.
actually the last time, madam.
That is what we can say.
The decision.
You do not place this. These are not to be guided by any precedents.
Yes.
There is no statutory backing in your prayer. Third, 3P Bharat was learned counsel for the petitioner. Also heard 3B Kaushik, the learned standing counsel, secondary education.
1, 2, and 3.
On to secondary appearing for the official respondent. This when the, no, when this matter was taken up for consideration on 26/5/2023, the same was adjourned on a prayer made on behalf of the petitioner. This court had also recorded the submission made by the department that the writ petition was not maintainable on the ground that the present relief is based on the fact that the petitioner was appointed in the year 2006, whereas 2006 by the managing committee of the school, whereas the school was provincialized way back in the year 1985. Sri Bharadwaj, the learned counsel for the petitioner, submits that the petitioner is working as a grade 4 employee in the Mohendra Narayan Chaudhary Balika Vidyapit, the district of Nalbari, and does not dispute the fact that his appointment was made on the basis of a resolution by the school managing committee dated 2/8/2006, and the school in question was provincialized in the year 1985. He, however, has placed before this court that his case for regularization has been recommended by the administration of the school, considering the long period of service rendered, and is presently before the inspector of school, having regard to the settled law on this ground, in this regard, wherein it has been laid down that a school managing committee shall not have any jurisdiction or powers in the field of making appointments in a provincial school, comma, this court is of the opinion that the present petition has been filed on a misconceived perception. Accordingly, this writ petition is dismissed. However, while dismissing the writ petition, comma, it is observed that as and when any vacancy in as and when the any vacancy which may be existing is filled up, comma, the case of the petitioner is may be considered, and while doing so, the experience gained by him may also be given some weightage. Eight. What is this matter? Is there any interim prayer? What is the interim prayer?
The state operation of order dated 4/5/2020, case number 20.
What is that order?
And he has been shifted to the original post which he is holding.
Okay, let him come then.
Let it be there for tomorrow, my lord.
Ask him to come after some time. Yes, thank you. Mr. Bhuya,
Matter, my lord, for adjustment with the sanction taken forth, market, college, in provincial election in there 2005. Now, petitioner was appointed on 4/9/1990. It's at the stage. And now, my lord, two LTA post is laying vacant. College. Now, lord, the petitioner already approached the court by filing the petition along with her. That is page 26. Court will observe if enrollment increase and then there is consider page 26 and could not secure the benefit of provincialization as the position was fifth among the LDA. Now, observation was saying that page 29, she in the art field justifies sanctioning of additional post.
now you say that there are two numbers presently.
Now, two post laying vacant.
Now, what is the basis of your claim for adjustment?
Because he already been tendered for 30 years.
There may be other candidates also.
Now, my lord, so far,
Okay, we'll issue notice.
so far, my lord,
My lord,
election is concerned, my
instead
lord.
of issuing notice, my lord, maybe dispose of by, my lord, one. If execution is pending, my lord, ultimately government has to take a call on his, my lord, prayer. Because
You take
adjustment-
instructions on the factual part. We'll say that.
Otherwise, my lord, his case is on, there is no case of him, my lord, because the petitioner was admittedly working in a non-sanctioned post, my lord, and there is no provision in the act or even the Supreme Court also says that non-sanctioned post cannot be regularized by, my lord. There is a rule
Okay,
for.
we'll heard counsel for the petitioner, who by means of this application has prayed for a direction for adjustment of the petitioner against existing vacant post in existing vacant grade 3 post. Correct?
Yes.
Full stop. Grade 3 post in the Harupatia College in the district of Doram. Full stop. On the other hand, comma, 3 as the standing concept. This is higher education. Higher education department has submitted that there is no legal basis of making the present claim as the post in which the petitioner is claimed has been claiming to be working is a non-sanctioned post, and there cannot be any regularization of such employment. Full stop. Para. Be that as it may. No, he further submits that the writ petition may be disposed of by directing consideration of the representation so filed by the department. Full stop. Para. Be that as it may, comma, let notice of motion be issued, returnable by 4 weeks. 6 weeks to re-draft the learned standing concept. Higher Education Department accept notice on behalf of respondent numbers 1, 2, 3. Okay, finance. 3 B Google learned standing concept finance department.
My lord, I am referring 1 and 2, my lord. 1 and 3, my lord. 2, 4.
Oh, 1 and 3. And 2 out 2 you write 2. MSD Das Verma. Learned state concept for 2 and Google finance. Let extra copies of the repetition be served upon them by tomorrow. Let notice be issued. No, let steps be taken for service of notice upon the respondent numbers 5 and 6. Queries that possibility steps by tomorrow. Para. Pendency shall not be a bar. Not trusted. Pendency shall not be a bar for consideration of the representation dated 3/4/2023 of the petitioner, which however may be done quickly in accordance with law. Camping is not, don't make it a practice. Camping will not allow. Today we are doing, tomorrow onwards no timing. We'll adjourn for 1 day. Next day we'll have. Yes, after some time.
I this petition for the PLC matter. If of the other were died, other were the primary school teacher. I and
Was it rejected earlier?
I just that I submitted the petition to them.
Where?
Yes, my lord, there are
No, paper. Where is the document? Where is the document of rejection?
I submitted the application. Yes,
We have seen the application.
yes, 15.
Mr. Ahmed, we have seen the application. Where is the rejection?
Actually, we have to pass any order, but they put a circular where my name was mentioned that I submitted that application lately.
Where is it? Yeah, and this is the application of 2009.
My application dated 19/7/2010, and which was placed before the PLC 10/8/2011 by the by the state the PLC issued an order that I have submitted.
No, the last communication is 2010.
2010.
Thereafter, you have come this before this court into 2023. How have we explained the delay of 13 years? Where?
My father died on.
How have you explained the delay?
2009, well, I applied for the application for professional development method, 1907-2010, my lord. But DLC passed order on 10/8/2011.
From 11 to 2023, what were we doing? Why have you come now?
I appealed before the DLC, but the authority concerned several times, my lord. But there is no record.
Sorry?
Here. But kindly see, my lord, page 17, my lord, communication order, my lord,
17 is 2010.
2010.
From 2010, we're in 2023. How many years? Recruit is not meant for that. You sleep over your eyes for 13 years. Suddenly you wake up from a deep slumber and come to the court. Don't think.
Only taking a direction, my lord. Submit
We are directing for cancel for rejection of your writ petition. Yes. Part 3. Title number. Your A.N. Ahmed, Learned Counsel for the petitioner, who by means of this petitioner also heard MSD as government learned education. I also heard P.A. Fukan, learned standing council, elementary education department, and MSD das government, the learned state council. Para. The petitioner, no, by means of this writ petition, comma, the petitioner is making a petitioner is making a prayer for consideration of his case for appointment on compassionate ground. Full stop. As per the projected case, as per the projected fact, comma, the father of the petitioner, Yogeshwar Medak, had died in harness on 28/3/2009 while working as head pandit of 806 number NO number Sumoni Medak LP School in the district of Lakhimpur. Full stop. The petitioner claimed that an application for compassionate appointment was made in the year 2010 and has also referred to a communication dated 19/7/2010. However, no further documents have been annexed to a submission has been made that the application of the petitioner for appointment on compassionate ground has been rejected in the year 2011. MS both Sri Fukan, the learned standing council of the department, as well as MS Burman, the learned state council, have submitted that the writ petition is not maintainable in view of the inordinate delay of about 13 years, which have not been explained at all in the petition. They after hearing the parties, this court is of the opinion that the entire objective and purpose of consideration for appointment on compassionate ground is to give immediate succor to a family which has lost the sole earning member. However, as rightly pointed out by the learned counsel for the respondent, that there is an inordinate delay of about 13 years in approaching this court, which exercise equitable jurisdiction, and the said delay has not been explained in a proper manner. Full stop. Para. In any event, comma, after 13 years, comma, the objective direction for consideration for appointment on compassionate ground would not be in consonance with the objective of the scheme. Full stop. It has also been settled that such consideration for appointment on compassionate ground is not a mode of recruitment, but only an exception to such mode under peculiar circumstances which do not exist after such a long delay of 13 years. In view of the above, the writ petition stands dismissed. Yes, next.
The second round of Petitioner. Earlier round of the matter was remanded to the authority. Now the authority has passed the order of the
36.
basically on the ground that 2017 and 2017-18, the enrollment was less than
Enrollment.
enrollment of was less than.
There is no requirement for another teacher.
So now you will also have to come.
What is your name? Lukesh or Sangmai?
We have three stars.
No, your name, Lukesh or Sangmai, or three of you are there. And Anita Chamua. But this is a factual determination.
Yes,
27. Yes, please.
They are saying that 16-17 and 17-18 was less than. But the requirement was case 27 from lawsuit 2019 to 2017-18 and 2016-17 immediately 27 and 2017-18 enrollment was so it is not less than 30 and requirement is that as per protocol so far the protocol.
Okay. Part 3 M. Khan. Senate counsel for the petitioners who are aggrieved by an order dated 9th of January 2023 passed by the Director, Elementary Education. Full stop. The Learned Counsel submits that the decision is based upon certain facts which are erroneous on the face of it. And those facts relate to the numbers of enrollment. Full stop. Para issue notice returnable by 4 weeks. 3 B. Caustic, the Learned Standing Council, Elementary Education Department, accept notice on behalf of respondent numbers
1, 2, 3, and 5.
1, 2, 3, and 5. SSA,
FSA, Mr. Asbora was there.
6, madam, you will be taking. SSA, Asbora,
Asbora,
Mr. Bhuya, Asbora. We record your name. 3 M. Bhuya, Learned Counsel, assisting 3 Asbora, accept notice on behalf of assisting 3 M. Bhuya, Learned Counsel, accept notice on behalf of for respondent number 4 SSA on behalf of the standing council 3 Asbora. MS Read as Burman, the state council for respondent number 6. Sarah, let extra copies of the writ petition be served on the learned council by tomorrow. Yes, sir.
So there is a matter coming up. Because it's on to court. Tomorrow. So lordship will kindly to the last order at page 19.
You like to have this tomorrow then?
No, my lord, your lordship is your notice. We are protected by the process. So lordship will not pass separate order.
Okay.
It will cover, the lordship can say this covers this. Kindly say 190.
192,
190.
190.
My largest term is the first of it. Kali has to cover earlier. Kindly see at page Kali 6 for us.
Malad, may I submit, Malad? Malad, actually, we have
Not proceed holding with
missed
it.
the matter, Malad, because our names are not shown, Malad, higher education, Malad. We have missed the matter, Malad. Similar matter is pending tomorrow.
Coming up tomorrow. We'll have this tomorrow then together.
Will not be there, my lord. My request is that
We'll pass the same order.
same order. Can it be,
Or-
their urgency is there. Their
No,
urgency.
you're already protected by the direction. This is a general direction,
Same.
not to
Only
hold the
your
test.
lordship, one request, my lord. If this matter come, I told Kostav also that it can be taken up on Monday.
Then, Malad, pass over this matter, Malad, because interim order is there. Although there is a similar order,
No,
there is an
what I'm
order,
saying,
Malad.
my lord.
As
No. What we have noticed
No.
that this interim order is not pertaining to a particular petitioner. It is generally in nature
yes.
whereby you have been debarred from proceeding with holding the teaching proficiency test.
Yes, yes,
Whether it is in one petition or 10 petition will not matter.
Correct. Right.
There is a bar for you.
yes, sir.
We'll consider whether we continue or not, but it has to be done in presence. As he has requested, we'll do it in his presence.
Malad, my humble submission, Malad, kindly pass over this matter, Malad, because that matter was dealing by Mr. K. Gogoi. He is held up in another court. I will take
No.
files
See,
to chamber,
Mr.
Malad,
Das, see,
after some.
you are making a prayer, but your prayer has to be reasonable. We are not going to change our mind.
That's why
This is not going to change. This is not
But
something
order has to
extraordinary.
pass in his presence, Malad, because I was not, I am not dealing.
We'll record his name. What is the problem?
I am not asking something beyond that. My
See, a court has already applied its mind and fixed the matter tomorrow. Until then, very yes, Mr.
lord.
Mr. Gogoi, you have threatened him with like he's not making any concession in your absence.
My brother says that our name is not shown in this case, Lordship, and we have also not no knowledge regarding this.
See,
Lordship, if tomorrow another matter is fixed. My lord may fix on tomorrow,
tomorrow, senior counsel has made a request that tomorrow he's not be there.
Lordship.
And tomorrow's matter, a prayer for adjournment will be made for Monday.
Lordship.
And since there is an interim order of
Yeah,
general
the
nature,
earlier case, Lordship, will not do because this case, Lordship, may no need to pass any order.
that is it.
Lordship, will not.
There is a general
Lordship,
restriction
general Lordship.
that you don't hold the proficiency test.
Lordship.
We'll have this on Monday then,
My lord may take it Monday and Lordship may.
or we'll do one thing. We'll have this tomorrow along with that case. We'll have it on Monday.
My lord may on Tuesday, Lordship.
Tuesday. No problem.
Tuesday, Lordship may.
Read as learned senior counsel. For the petitioners, submit that the issue in question has already been raised in WPC 2286 2023, in which, this court had passed an order dated 11/5/2023 issuing notice and had also made an observation that till the next date, the authorities will not proceed with holding of the teaching proficiency test within bracket TPP para. The learned senior counsel has fairly submitted that the observation made in the other writ petition will also cover the cases of the present petitioners. Full stop. Para. Since K. Gogoi Standing Council of the Department submits that no separate interim order is required to be passed, as the interim order has already been passed in the other recruitment, which is slated to be listed tomorrow within bracket date full stop para. In view of the aforesaid facts and circumstances, comma, list this case tomorrow along with WPC.
Otherwise, Lordship also posted the matter on Tuesday. Lordship will mention that matter on
No, tomorrow, since one matter is coming, that common order be passed for Tuesday.
Lordship.
Tomorrow will pass.
Lordship.
Along with
Output column है.
along with WPC double 286 of 2020.
Order to column. Same, double to.
My lord, may
Ito agote mari.
kindly reflect our name, Lordship. Due to this, we are
Registry is directed to reflect the names of Standing Council, Higher Education
Lordship.
Department.
Item number 18 of
16 and 18 same, Lordship.
one is regarding in respect of engineering college, another is polytechnic.
Same order.
I'm with you online.
Yes, please. Page
Page 41, my lord, Chapter 8. There are 5 petitioners, my lord. The order has been passed, my lord, only are being put to the petitioners, my lord. By this order, my lord, the entire session process, my lord, and appointment of the petitioners will be captured, my lord. So, getting any reason.
Okay, we'll issue notice then.
My lord, one small query there, my lord. In the meantime, my lord, this advertisement has been issued by the President Director, my lord. And it kindly come to this, my lord. 46, my lord, lesson 9. This had the proof, my lord. All about the Assam, my lord. Here, my lord. At 47, the name of the at number 21, my lord. So that 14 proofs have been addressed, my lord. And here, my lord, the proofs of the papers are also in place, my lord. Papers are also in place, my lord. My lord. In respect of, my lord,
We are not taking up recruitment process.
in respect of, my lord, most of the, my lord,
We'll say any appointments made in those posts will be subject to the outcome. We are not making a
my lord, if, my lord, they, my lord, when, my lord, that, my lord, my lord, they have expected.
we would say it will depend on the outcome of this writ petition. We'll have a rider. Item number J Islam. Third is J Islam Learned Council for the petitioner. Petitioner. The petitioners are aggrieved by an order dated 23/3/2023 issued by the Director of Education, BTC, whereby the entire recruitment and appointment connected to those of the petitioners in the for the post of graduate teachers in Adarsha Vidyalaya, Kusugao, in the district of Kokrajhar has been cancelled. Various grounds have been cited in support of such challenge. the learned council has also submitted that after such cancellation, comma, by an advertisement notice dated 10/5/2023, comma, a press recruitment process has been initiated, including 14 numbers of posts in the district of Kokrajhar, which, according to the petitioners, would also include the post in which they were appointed. Para issue notice returnable by 4 weeks. Mr. Abha for
4, 5, and 6, my lord.
And for one.
3 SMTC Learned Standing Council, Secondary Education Department, access notice on response number 1. RMSA, B. Gogoi,
2 and 7 I'm
Standing Council, RMSA, access notice on behalf of response number 2 and 7.
7, fine.
2, Standing Council for RMSA as well as Finance Department, accept notice on behalf of response number 2 and 7. 3, SR Rabhat, Standing Council, BTC, accept notice on behalf of response number 5, 4, 5, and 6. That extra copies of the writ petition be served in the learned council for the respondents by tomorrow. Let steps be taken for service of notice upon the response number 3 by registered post to KG. 3. Islam, the learned council for the petitioners, prays for an interim order for stay of the recruitment process initiated by the notice dated 10/5/2023. This court, however, is not inclined to pass a blanket order of stay on a recruitment process. However, it is observed that any appointments made in the vacant post in the district of Kokrajhar, which were earlier held by the petitioners, in Kusuga others of Vidyalaya, which were earlier held by the petitioners, would be subject to the outcome of this petition. Madam, your matter was okay after this. Fine.
To whether who have got their qualification, well examination of the different class of whether of those who have got their qualification under the system. And therefore, the authority liable to consider them separate while evaluating their merit for employment in government jobs. That is the issue. And a collateral bench of the Honorable Court has already held in favor.
Yes, Mr. Kaushik. How would the mode of examination determine their state of consideration?
Well,
Because they are not to be faulted with whether it was an annual examination or semester system. And if it is already considered by a coordinate bench,
at this thing, allowed to issue notice because they have not challenged any recruitment process where they have been deprived of it.
where is the earlier judgment, Mr. Mohanto? The direction at page 48.
Case 48.
The last part of the order.
Page 47.
Page 47, not
The 33. Yes, at page 33. Revise. Yes. You are directed to rationalize the mark. You do so. You We can dispose this of,
Yes, in the same
we dispose this of
similar.
similarly. Heard K. Mahanta, the learned senior counsel for the petitioners assisted by Sri M. H. Ansari, learned counsel, Ansari, learned counsel. Also heard Sri P. Kaushik, the learned senior counsel, elementary education department for
Both respondents.
both the respondents. Considering the subject matter in dispute and also being apprised of the fact that the controversy involved has been resolved by this court by judgment and order dated 21/6/2022 in a batch of red petition, the lead case being WPC 1040/2022, this red petition is taken up for disposal at the motion stage itself. Para. However, however, it will be convenient to record the facts of the case in brief. Full stop, Para. The petitioners who are 20 in number, please have your seat. Have your seat.
Hello.
20 in numbers have obtained their graduation through the yearly system of curriculum. Full stop. However, yearly system of and claim to be undergoing a stricter evaluation in their examination compared to the semester system. Full stop. The issue is with regard to the consideration for appointment as teachers in post of LP and UP schools, whereby a common eligibility criteria for both for candidates coming from both the streams have been laid down. Full stop. Para. The Mahanta Senior Counsel has submitted that as reflected above, the issue was raised in a batch of writ petitions, including WPC 1040/2022, which were resolved by this court by judgment and order dated 21/6/2022, in which, after recording the submissions, the following directions have been made. Paragraph 33. The senior counsel for the petitioners submit that the petitioners would be satisfied and the interest of justice would be met if a similar direction is passed. Full stop. Para. 3B. Caustic, the standing counsel of the department, does not oppose the aforesaid proposition in principle. Full stop. Para. In view of the above, this writ petition is disposed of in terms of aforesaid direction made in paragraph 33 of the judgment dated 2022. And a similar consideration is also directed to be made so far as the petitioners are concerned. Writ petition according to the census. 34 is not required. Modified. 33.
34 is with regard to modification.
Okay. So come after 5 minutes.
Please, the lordship from Delhi, I don't know.
The standing counsel
some advocate from Delhi, Lord. I don't know. They have it.
No, you have served upon the standing council.
They can send notice to regional director also directly.
No, before serving, before filing, you must have.
Yeah, before filing, they have to serve to Delhi. There is a problem. Before filing, they will able to copy.
No. You have not served upon. I think only because NIOS the standing council has been reflected.
But I have not received the copy.
No, doesn't matter. No, it's not been served upon it.
I thought they one thing, but they have published it to the director chairman. So I pray for it disposing of directing them to dispose of our representation on examining what we have said.
No, without instructions, that will not be possible. Who is otherwise appearing for the school education? Anyone from the department? But I think it is the NIOS which will have a. Please to notice. I heard the AFNU Mullah Learned Council for the petitioner. Full stop. Para. By means of this petition, comma, the petitioner has expressed his grievance regarding an order dated 20th of May 19. Challenging now after so many years.
Before every examination, they say that we are passing the matter and they are just giving assurance.
Whereby the Daleshwar Girls High School in the district of Walpara, of which the petitioner claims to be the headmaster, has been made a study center for NIOS with the accredited institution AI number MO 2069 and a former principal of the school. Response number?
It's not my lord respondent. He's already retired.
But he is.
He's 19, my lord. He's retired.
Why have you not made him a party?
He's 19, my lord. He retired on 31st 1 2019. Last before his making this order, he was.
With the name of one, which school 3 Abu Talib was named as the coordinator, who, according to the petitioner, had retired on 31/1/2019. Full stop. The petitioner submits that it is the principal of the head of the institution accredited by the NIOS, who should be the coordinator of the institution.
But there is a
Para. MS R. Bora, the learned counsel, has, however, who was requested to appear, has, however, submitted that he is no longer the standing counsel of NIOS. Para. Issue notice returnable by 4 weeks. 3B Caustic Learned Standing Council. Standing Council Secondary Education Department accepts notice on behalf of respondent was 1, 2, 1, 2, and 6. That extra copies be served upon him by tomorrow. let steps be taken for service of notice upon the response numbers 3, 4, and 5 by registered post PTD. Steps by tomorrow. Pendency of this petition, however, shall not be a bar for consideration of the representation dated
Dated my lord 13/1.
13/1/2023, which however has to be done strictly in accordance with law.
For non-payment of salary or date of
Non-payment of salaries.
salary lot
You are working as what?
as a tutor lot. Order of provincialization is at page 11. Service was provincialized as a
5 to 21.
5 to 20.
When did you enter into the services? When did you enter into the services?
In 1992,
92.
92 lordship as a assistant teacher of Nobility Elite School. Subsequently, his service was provincialized on 5 to 2021.
Yes, what is this, madam?
Notice movement.
Heard Redeka, current counsel for the petitioner, who by means of this application has paid for a direction for release of his salary for the services rendered by him as a tutor in the 28 number NO Deka Senchua LP School, Mazuli. The petitioner claimed that he was initially appointed as an assistant teacher of number 2 ME School, Mazuli, and was regularized as a tutor of the school in question by an order dated 5 to 2021, in spite of which he has not been paid his salary. He submits that though his regularization was the subject matter of audit proceeding, the same was disposed of by directing the parties involved to avail remedies under the Education within bracket to ensure provincialization of service to ensure bracket close Act of 2017. Para issue notice returnable by 4 weeks. MSN and Standing Council Elementary Education Department accept notice of they have to respond numbers
1 to 4.
1, 2, 3, and 4. Oh, all the respondents. Para
Tendency of the repetition may not be a part.
Para tendency of the repetition shall not be a bar for consideration and payment of the salary to the petitioner. Yes. Your part.
11. Number 11.
What is your name?
Okay.
Okay. To issue a short notice, will dispose this of.
Yes, because this was minutes of 2017 notice. Page 22 notice.
17. Where you late? When was the death?
On 14/11/2016.
From 17 to 23, what were you doing? Hmm?
I have approved the authority. There are 10 methods. That's for oriented 2015.
In para 10, those certain statements have been made, but you approach them for 1 year, 2 years, but this is the delay of how many years?
6 years only.
6 years. Or to approach the court, set to a writ court exercising equitable jurisdiction. Third, Riyas as a recurrent concept for the petitioner, who is aggrieved by the rejection of the case of the petitioner for appointment on compassionate ground. He submits that the rejection is only on the ground of lack of vacancy and not on merit. On the other hand, Sri S.R. Burwa, the learned state council, submits that the rejection is of the year 2017 and this petition has been filed after a long 6 years without proper explanation. Be that as it may, that notice of motion be issued, returnable by 4 weeks. Elementary, who is there? Who can? Elementary. Madam? Elementary? And who can? Understanding of the elementary education department accept notice on behalf of record was 1, 2, 3, and 6. Whereas
Five and six.
5 also, my lord.
5 and 6. Whereas response number 4 is represented by Sri S.R. Burwa, the learned state council of Para. That extra copies of this petition be served upon the learned council for the party. The aspect of delay as raised by the respondent would, however, be considered on the subsequent day.
Obliged.
Hmm.
After getting the information through RTI, it seems that they have used the cyclostyle letter giving reply to everybody. But then I filed a statutory appeal under Section 14. So let them file and decide.
You have already filed?
Yes, sir.
Yes. Who's there?
That is the page 70 annexure 16 on 9 February.
Elementary, madam?
Ma'am.
He is only seeking that the 14 appeal should be disposed of. Pass a direction?
Yes, ma'am.
Heard. Yeah, within learned counsel for the petitioners. Also heard. MS. And Fukan, the understanding of the elementary education department, as well as we go standing council, Sarva Shiksha Abhijit, SSA. Considering the facts and circumstances of the case and the nature of relief which has been prayed for by the council, by the learned council for the petitioner, the same is the petition is taken up for disposal at the motion stage. The petitioners are aggrieved by the action of the state level scrutiny committee in not recommending the petitioners for provincialization of their services. In spite of such recommendation by the district level scrutiny committee. The rejection, comma, as contended by the petitioner are done in a mechanical manner without any application of fine, and no reasons have been assigned as to why the recommendation made by the DLSC could not be accepted. Were not accepted. The Aberdeen learned counsel for the petitioner has, however, submitted that under the Act governing the bill, namely Act of 2017, an appeal has been preferred under Section 14, which is pending consideration. The learned counsel submits that for the present, comma, the interest of justice will be served if a direction is given for consideration and disposal of the appeal in accordance with law. MS Fukan, the learned standing counsel, as well as MS Fukan, as well as Sri D. Gogoi, learned standing counsel of the respective department, do not oppose the aforesaid prayer in principle. In view of the aforesaid facts and circumstances and the broad consensus arrived at in the bar, comma, the instant writ petition is disposed of by directing consideration of the appeal preferred by the petitioners dated 9/2/2023 by the authority prescribed under Section 14 of the Act. It is needless to state that the state consideration is to be followed by a speaking order. Which is to be communicated to the petitioner. Is there a scope of hearing?
No.
Uh, the petitioners may also be given a personal hearing by the authority who may present all the necessary documents in support of the appeal be disposed of expeditiously and preferred within an outer limit of 3 months. When did you file? March. Outer limit of a further period of 2 months from today.
No.
Is it to facilitate such consideration, comma, the petitioners are directed to furnish a fresh copy of the appeal. The fresh copy of the appeal along with the relevant documents before the appellate authority within a period of a week from today. Because that may not be traced out, it will be difficult.
Advertisement of selection in respect of the principal took place. There is selection committee and talent person, and I have talked. But unfortunately, what happened? The person who was holding the charge was there. She came before this honorable court and stated the further procedure of that selection. Ultimately, because of that, my lord, and somehow, my lord, though the order was passed, restraining order, but your lordship is aware that at that period of time, the state used to give 21 schools together as the approval for the principal. My name also occurred there. But when realizing that mistake, they recalled this approval. And ultimately, my lord, the vacation order was allowed and the interim was vacated. They approved the division bench.
The division bench allowed that interim order of the learned single just to be continued. Subsequently, my lord, the division bench remanded back the matter to the learned single.
Petitioner retired. Yeah, in that case.
Yes, yes. And then petitioner retired in the month of February, and after that the petition was closed. After closure,
You want to contend that as on today there is no restriction.
no, this there is a order from the
Page 42.
page 42.
Yes.
I'm Nilakshi Lahan. And my lord, last part of this order. The government is therefore requested kindly to issue a fresh approval for appointment of regular principal in the name of Nilakshi Lahan as recommended candidate of SSP by date dated so and so.
Okay. Now what is your cause of it? What is it of 22?
Yes, it's not done for 1 year. I don't know why.
My lord. Lordship can dispose it, my lord, directing the secretary to act upon this recommendation, my lord, and
No, I
grant the
think it would be more appropriate if, my lord, by next week they at least
You get the instruction.
yes, let them get the
You
instruction.
get the instruction. Okay.
After disposal, why should I come for contempt and all this now?
Third, 3 Abedin, Senate Council for the petitioner. Full stop. The petitioner is presently working as a subject teacher in English in the Saboti Welfare Multipurpose and HS School, Lakhimpur. Full stop. In the year 2018, a recruitment process took place for filling up of the post of principal of the school on regular basis, in which the petitioner claims to have been selected against against serial number 1. However, this selection was the subject matter of litigation instituted by the in charge principal, which continued till the year 2021,
Till February
till February 2022. However, by that time, the petitioner in the state case, named who was the in charge principal, had retired from service on attaining the age of superannuation. And noting this aspect of the matter, the concerned writ petition WPC 8325/2018 was closed. Full stop. After such closure, the petitioner had filed a representation before the Director of Secondary Education, who, on consideration of the same, had passed an order dated 31/5/2022 requesting the department to issue fresh approval for the petitioner for consequent appointment as principal of the school. Full stop. The learned council submits that though almost a year has
exactly a year.
although a year has expired from such communication, till now nothing has been done. Under those facts and circumstances, this court is of the opinion that instead of issuing notice, let some time be granted to the department, to the council of the understanding council of the department to obtain instructions for the para. According to this, 3B Caustic, learned standing council of the department is directed may obtain the instructions. Obtain the instructions. List this case on. Tell us.
No problem.
9th is okay, 9th of June 2023. Full stop. Three evidence, the learned counsel for the petitioner may serve an extra copy of the petition
during the day.
to the Kaushik to enable him to do the needful.
If the lordship is the one writer, there may not be a bar. They might give it.
1 week per per. We are considering on 9th.
If your lordship.
Case was rejected on the ground of that the time of death his father did not have the balance.
What about the division bench?
Lordship, we have prepared an appeal.
What has happened?
There is some delay, Lordship, in the
What-
IA. No.
Where is Madam Das? Yes, what orders have we passed?
In the case, notice has notice has been issued, returnable by 4 weeks, on 3/5/2020.
In the writ appeal?
Yes.
In the delay condemnation?
So delay economy.
No, what orders were we passing here? After 4 weeks?
So at this stage,
And giving liberty to make a mention in case it's decided.
Lordship.
Heard MSSB Chaudhary, Senate counsel for the petitioner, who by means of this application has put to challenge the rejection of the case of the petitioner for consideration for appointment on compassionate grounds. Full stop. It is submitted that the rejection is on the ground of balanced period of service. Balanced period of service of the deceased employee. Full stop. Para. This court, however, has been apprised by the learned by Sri S.R. Barua, the state counsel, that the issue is presently pending consideration before the Honorable Division Bench, in which, notices have been issued on the aspect of condemnation of delay. Under those circumstances, this court is of the opinion that this matter be deferred by a reasonable period, so that the matter can be resolved by the Honorable Division Bench. Para. Issue notice returnable by 4 weeks. Pre elementary and for understanding council elementary education department accept notice on behalf of as per numbers 1, 2, 3, 4, 5.
Yes.
Full stop. 3 S.R. Barua, the state council accept notice on behalf of response number 6. Para. That extra copies of the state petition be served upon the learned council for the response by tomorrow. Parties are given liberty to make a mention of this matter in case the issue is resolved. In the event the issue is resolved by the division bench within the returnable date.
Lovely.
Yes.
The method relates election and appointment of principal in court. So, the year 2019,
Hmm.
thereafter, lordship interview was now participated in this selection process, and ultimately under the
You are the first.
yes, sir. The school selection committee recommended mine and thereafter forwarded this selection report for its approval. But the school selection committee was considered the candidature of the response number 7
7.
on the ground that he is not having the eligibility criteria.
That was put to challenge.
Essentially, the lordship, the response number 7 approached the honorable court and filed the lordship that lordship will find an annexure 18 page 46.
So ultimately, this honorable could give a direction to the authority to reconsider it, re-examine the matter, and if the petitioner in that particular issue also allowed to participate in the election process. So ultimately, the process was initiated on 6th of March 2020. And the petitioner also participated in the selection process. Lordship, that I have given the comparative statement of section 19, page 51.
No, ultimately the
Now, Lordship, ultimately this school selection committee record has been verified by the selection board. And from the board, we come to know that the petitioner is scored Lordship 19 marks. Now, only my hurdle is that Lordship, after the recommendation of the selection board, as per rule Lordship 233, the government is the
why are you entitled to 2 marks under 4C?
because Lordship in the SCR Lordship, the school selection committee has granted 1 mark. Since I am having Lordship very good Lordship, that is why I am entitled for 2 marks. So ultimately, the school selection board has granted 1 mark. And second Lordship, so far the
No, what is the total marks vis-a-vis 18 and 19?
18 and 19. So
You have
ultimately, I
scored it 18.
No, I scored 90.
Then
That should kindly see page 50.
then why is he given
But
the
that is till date Lordship, because it was done on 26th of November 2020. But till that government has not given approval of the recommendation made by the legislature. That is number one. Secondly, Lordship, so far the candidature of the number 7. Lordship, he is pursuing the MATQ to distance.
if the markings which have been given allotted to you and respondent number 7, excuse me. If you have scored more marks
Yes, Lord.
than respondent number 7, we need not go to the aspect of eligibility at this stage.
But the difficulty is that because we constrain the time period. Lordship.
No. There first aspect of obviously will go, but since the selection is not put to challenge by respondent number 7 by a second round of litigation, that means that position has been accepted, wherein you have been given more marks than the respondent number 7. You are only aggrieved by that they have not given an end to the final selection.
Yes, Lord.
They have to bring it to a logical conclusion.
Yes, Lord.
We'll consider consider that aspect. The eligibility part at this stage, since he has not come before the court, that will remain open in case he contests.
Otherwise, the rule 13 says
No. How will it matter anything since you have given more marks?
Yes.
It can be a ground of additional challenge if and when he is required. Yes, but
Yes.
you take the instructions. Will issue short notice. And this selection was done by the state selection board when? 2020.
At 26th of the elected 21 page 3 after
26th of November.
record, as per rule after the record forwarded by the school selection committee, that will be again verified by the school selection board.
20 to 23, what are you doing? No, 20 to 23.
No.
If they come up and say that we have not done anything for 1 year, we are not bound to be hard, create a concurrent conflict for the petitioner. Also, the petitioner had participated in a recruitment process for the post of principal in the Hawazan Higher Secondary School in the district of Sonitpur, which was initiated by an advertisement dated 1/2/2019. Full stop. In the said selection, the petitioner was selected as the first empaneled candidate. Full stop. However, the aforesaid selection was the subject matter of a writ petition instituted by the present respondent number 7, which was registered as WPC 4988/2019 Full stop. The said writ petition was, however, disposed of by this court by an order dated 9/12/2019, directing consideration of the case of the petitioner as well as the response number 7 by the State Election Board. Full stop. Para. It is the case of the petitioner that on such consideration, comma, the petitioner was still the first empanel candidate by the school selection board, whereas the response number 7 was second. Full stop. The selection board. State selection board. State selection. State selection board. SSB. Para. While the eligibility of the response number 7 is still questioned by the petitioner, comma, the learned council has submitted that even overlooking that aspect of the matter, comma, since the petitioner has secured more marks than the response number 7, which has not been put to further challenge, comma, the petitioner ought to have been given the appointment based on the selection made by the state selection board in the year 2020, which, however, till now has not been done. Issue notice returnable by 4 weeks. 3. B. Kaushik, Standing Council. Secondary Education, Secondary Education Department accepts notice on behalf of
1 to 5 minutes. School selection. 1 to 5.
1 to 5 TO5. 1 TO5. That extra copies of the requisition be served upon him by tomorrow. That notice be issued upon the response number 6 and 7 by registered post with AD. Note step by tomorrow. Para. Not para. Yes. Next. And the advertisement has been issued. Then it will take a long time. You come in a IA if advertisement is issued. They cannot fill up within 1 or 2 days. 4 weeks. Tell us a date. Returnable to date. Returnable on 1, 2, 3, 4. On 28th of June. 2 weeks. No, we get up to I think we have to rise early today at 1 o'clock. There is some notification. We'll have it in the second half. For the day. Okay. Who is your senior? AM Borbia. On a prayer made on behalf of the AM Borbia, Learned Council for the petition matter stands adjourned to be listed on Monday next. On date today.
is procedure after report after facility to open facility. Other accounts of the some page 50.
Page
Page 50.
15.
So this is 11 was started back to full on the prayer of particular school. Then you wrote it
No. Page 15 is not reverted. 15 you have been made cluster coordinator.
wrote it just 50. 11
Page 15. This is 11/4/2022. Reverted back.
back that you wrote it. In fact, your study submitted a representative and then you wrote it. It is was not submitted. Then we continue. You wrote it. We kindly come to next page. Then you wrote it. There is a general order. 11/8/2020.
11/8. Page 17.
The general order. There were all shared.
Okay.
Then you wrote it. Then you wrote it by this order. In fact, there is a general order of release. Then by this order you wrote it. The earlier order. That is not in respect of the petitioner alone. As far as all this here.
Therefore, what is the ground of ten?
My ground is this. You wrote that then you wrote finally you wrote it. I was released by the year in the month of you wrote me you wrote it. He was again
2023.
Correct.
Released
my
from
ground
CRCC, SPRCC.
yes. I have to revert back to your school.
Mhm.
Now my ground is this. First of all, you wrote it. The ground on which the earlier principal you wrote it sought for my certificate. Because in the meantime, I have made a specific statement that picture is recruited.
There have been new recruitment.
New recruitment, so there is no necessity. He has not paid for my release anymore after the recruitment. And secondly, if you come to page 20, that is the agreement. 21, the agreement 20. As per this agreement, clause 5.
Page
Page
21.
Start from 21. 22 is the agreement.
Cross 5. Yes.
Clause 5. Part 30. By order of mission director.
Hmm.
I did not. SSA Assam, only mission director SSA Assam
Hmm.
may terminate the agreement at any time if finds services rendered by second party are unsatisfactory or if there is any confidence. The direction of the mission director Assam purposes of the mission agreement. final and final. But now, Your Lordship, ultimately, Your Lordship, the release will have to be effected either on the order of the mission director or by the mission director himself. Right? But here, Your Lordship, that is not there. Now, Your Lordship, that is my basic ground of delay. Ultimately, Your Lordship, there will have to be a termination of the agreement. And agreement, the termination, that is on the basis of simply because Your Lordship, someone wants me to be released, Your Lordship. Since my appointment was for 20, Your Lordship, section, I don't think.
What was three questions you'll have to answer. What is your substantive appointment?
My substantive appointment was whether
Number two, what legal right do you have to be retained as a cluster coordinator?
no,
Number two.
as such, I don't have. But
Number three, which you're basing on three grounds. There is no request from the principal.
Sure.
Is such request necessary? Number two, you said that new teachers have been recruited. That is not up to you to decide
no,
whether the. Number three, you said that agreement, there is a clause 5. Agreement is of the year 2013. It was for 1 year.
No, Your Lordship. That the agreement has to continue, Your Lordship.
Yes, what is the clause regarding the extension?
Lordship,
Have you read that? It is for 1 year and it extended unless there is a fresh agreement.
Lordship, it has been extended, Your Lordship. That's why, Your Lordship.
This 13 agreement, 1 year agreement has continued till 10 years.
That is, Your Lordship, will kindly see page in the
Then first you have to show your vested right to be continued. This is like a deputation.
No, that's true, Your Lordship. But this is my case is that it is only.
Yes, Mr. Bora.
When that particular point, my lord, that page number 21. In my petition, it is page number 21. That is the agreement, my lord.
Yes.
Very first paragraph.
Yes, sir.
The agreement. It is only for 1 year.
1 year.
It will have to be substantially extended.
By a fresh agreement.
Yes, my lord. And my lord,
where is the fresh agreement?
where is the
Your
fresh
Lordship,
agreement?
that is the point, Your Lordship. They have not executed any agreement, Your Lordship. They are allowed to continue. And Your Lordship will kindly see there is page 17 order, Your Lordship.
Not a case.
Page 17 order, Your Lordship, may kindly
17.
with reference to the subject cited above. This is for information of all concerned. That earlier direction of this office issued by so number hereby withdrawn with immediate effect. In case anybody is released from his or position, as CRCC pursuant to office earlier direction so the status quo and in regard to his or position
Yes.
4/8/2020 is also
Mm.
hereby restored with immediate effect. That is Your Lordship 11/8/2022.
Correct.
That Your Lordship will kindly see this is by the mission director. Now, if mission director decides that I should be released, then I don't have any case, Your Lordship. But it is not the mission director, Your Lordship. BMC, Your Lordship, without having any instruction from the order from the mission director, Your Lordship, has Your Lordship released me, Your Lordship, on his own. That is my case, Your Lordship. Now, agreement, so far as the agreement, Your Lordship, this is Your Lordship covered by these, Your Lordship. They have restored, Your Lordship, and status quo NP, Your Lordship. From that day, Your Lordship, when
That was of 2022.
22, Your Lordship, thereafter we continue in Your Lordship. If because their case, that agreement has ended, terminated, so you go. Then I do not have case, but that is not their case, Your Lordship. Their case is based, Your Lordship, and ultimately, Your Lordship, it is the
Mr. Aurobindo Kolita, you don't have a case.
mission director.
We are going to dismiss
I
your
don't,
case.
Lordship, I am.
Aurobindo Kolita
Your
is,
Lordship.
we are very sorry for Aurobindo Kolita. Okay, heard 3 as Bora Kulanet counsel for the petitioner. Also heard 3 as Bora Learned Standing Council. SSA,
IPF for 2 and 3.
SSA, whereas 3 if
For 1 and 4.
Learned Standing Council, Elementary Education has appeared for the respondables 1 and 4. Full stop. Para, the petitioner has put to challenge the action of the respondent authorities by which and as respondent authorities in issuing an order dated 4/5/2023 by which the petitioner has been reverted back to the original school. Full stop. Para. The case projected is that the petitioner who was working in a substantive post of assistant teacher of the Kuchi High School under the Haju Educational Block was deputed to work as a cluster resource center coordinator in the year 2013,
No, you're
15,
that's the academic
Agreement source is 31, 2013.
wrong date. But
15. Full stop. Pursuant to such order, comma, it is the admitted case that an agreement was entered into between the parties whose tenure was 1 year, subject to extension by a fresh agreement. Full stop. The petitioner claims to have continued in the post of CRCC continuously. Full stop. On 11/4/2022, comma, an order was passed to revert the petitioner back to the original post, which, however, was not acted upon on the representation of the petitioner, and he was allowed to remain in the post of CRCC. Full stop. However, by a subsequent order dated 11/8/2022, comma, all such CRCC has been released, pursuant to which, by the impugned order mentioned above, the petitioner has also been released from the post of CRCC. Full stop.
not on the basis of 11
Not
11
the- No, not 11/8. That 4/5. Subsequent. Pursuant to the subsequent. Para. The Watercourt, the learned counsel for the petitioner, has submitted that the impugned action is not sustainable in law on the following grounds. Number one, the action has been taken without due authority, as it is the mission director of the mission who is vested with such jurisdiction. Also, number two, there is no request from the principal, from the headmaster principal, headmaster, isn't it? Headmaster or headmaster of the school in question, in which the petitioner was substantially appointed to revert back the petitioner. Full stop. Number three, there has been new recruitment of teachers in the school in question, and therefore the proportion between the students and schools were maintained, and there was no requirement of such reversion. Number next, there is a clause in the agreement, namely clause 5, as per which the power to terminate the agreement is given only to the mission director SSA, which has not been done before the impugned action has been taken. On the other hand, Sri Bora, both Sri Bora and sending council SSA, as well as Sri Kukan, sending council of the department, has submitted that the initial arrangement was a temporary one for 1 year, which however continued for about 8 years. Full stop. It is further submitted that the agreement itself stipulated that the same was for a period of 1 year, and for extension, a fresh agreement is required to be executed, which have not been annexed to the writ petition. However, even assuming that such extension were made from time to time, the core question which requires a consideration is the lack of any indefeasible and vested indefeasible right on the petitioner to continue as CRCC, to which he was deputed only for a temporary period. Also, it is further submitted that the decision to revert back the petitioner is not dependent on the interpretation given by him on such requirement and on the teacher-student ratio. After hearing the parties and on examination of the materials on record, this court finds forth in the argument of the learned counsel for the respondents. This court does not notice any vested right of the petitioner to make a claim that he should be retained indefinitely as a cluster resource, as a CRCC, which as the initial order itself makes it clear that the arrangement was a temporary one for 1 year, which was extended from time to time. The other grounds urged are not cannot be treated as grounds which are within the domain of the petitioner, as the satisfaction is of the authority, both on the requirement of his service in the original school and also with regard to the teacher-student ratio. Though the point regarding lack of jurisdiction could have been a point for adjudication, in view of the fact that this court has come to a conclusion that the petitioner does not have a vested right to question such reversion, this court is not inclined to go to the aspect of adjudicating the said point. In that view of the matter, this petition is dismissed. Okay.
Was initially appointed in the year 1995. Sorry, salary of scale of it. The amount was allocated. Sorry, was
1 second. Take the microphone, I think it's off. Yes.
what effect how the that is the part of the best of it fine put is on a put those and architect by that method division investment based detail number 180 of based to 16 2013. During deliberation, the British authority has placed a policy decision without much good hope. That the British authority are going to regularize terms of to district salary up to 17,000. Though I am not party to the
But your termination is of the year 2006.
That was challenge to the honorable. Ultimately, that is party and the
Even from 15 to 23, 8 years.
thereafter, my lord, what is that I was closed in the year 2021 on 5 of the so that my lord, I have two different my apple submission will be done. My case is considered.
I don't think it deserves consideration.
that
You are sitting on the fence.
Yes. I am with my lord.
You are sitting on the fence,
Only the
enjoying the show. Now the show is in favor of somebody that you have come.
I am with my lord. There is that's my lord.
Yes, ma'am.
Yes, Lordship,
Only representation may be.
my submission is also that Lordship,
Not a case for a
Even-
report.
taken into account the division bench order, Lordship, then also Lordship from 2015 to 23, 8 years.
They have tried
That was by the state, not
this 26 I have
That is not a ground.
20
We don't see your bona fide.
paragraph
You have slept over your rights. Sorry.
20.
Sorry, not a fit case. Heard 3 and Sharma, Learned Counsel for the petitioner. Also heard 3 B Chaudhary, Learned Pending Counsel,
I may be allowed to comment.
B Chaudhary,
for BTC.
Learned Pending Counsel, BTC. Whereas the state respondents are represented by, yes, education by Sri SMPC, Learned Pending Counsel, as well as Sri Chaliha, A. Chaliha. The petitioner is claiming consideration on the basis of a litigation in which he was not a party. The impugned order relates back to 2006 and the writ petition was disposed of on 2013. Further, the writ appeal was also disposed of in the year 2015. The ground of delay is a substantial ground which had arisen for consideration before a court, before this court exercising equitable jurisdiction. At this stage, Sri N. Sharma, Learned Counsel for the petitioner, begs to withdraw this petition. Liberty to approach whom?
Lordship, that is
That is will not give you liberty to raise any fresh cause of action. Withdrawn. Petition accordingly shall be withdrawn. Dismissed on record.
apply.
Take care. What are the date of the judgments?
Judgments, my lord, immediate judgment is, my lord, 2015.
26 or 22/7. This is not a date of hearing. What are you doing, Mr. Saikia? In the index. Not the 6/8. And the review judgment.
Judgment is, my lord, 1/12/2020.
Let us see the review judgment
by the case
on 5. Page 20. Yes.
accordingly give the error apart if the take the past or if the record. Therefore, there is no if either an actual exit or the error it is the record. Code is also in line with the participant of published and protected fact was placed in a known the petitioner ground of by the state letter and the by the video for which the state the are protected the custody of the under the code like the first for one of both the evidence like that the document have been the first therefore the code is designed that well ground for doing the data coding the exception is this the respondents have applied for year 28,000.
But what about the, when did you institute this application?
The file on 2311
Review petition, contempt petition. So this is pending since 22 at the stage of motion. Yes, yes, madam. Are you appearing? For whom? No, no, no. This is a contempt matter. If you wish, you can appear. We are not compelling you. This is party by name. We'll issue notice because we'll be taking stringent action. We cannot force somebody to appear. What? You have to file an application. We cannot allow, this is by party by name. You have to make whole changes. Vijay Chaudhary is not there, I think. Neither is Samir Sinha there. Panindra Jijung is also not there. Praveen Chandra Rabha is also not there. Mr. Saikya, since you have approached in time, I don't think you'll have any problem. You file I. Will allow the IA, and before filing the IA, of course, you know what to do. Send notices to the new incumbent. And you file, we'll allow the IA, we'll see what we do in this matter. After failure in the review, non-compliance, this is not be tolerated. We have seen 50,000 cost. But before filing the IA, you make the amendments. Hard free IHCK learning concept for the petitioner. Sarah, this petition is pending at the stage of issuance of notice from the year 2022. Full stop. The learned counsel for the petitioner, Sri Saikia, has, however, informed that in the meantime there has been changes in the post held by the incumbents who were made party respondents. Full stop. He accordingly prays for some time to file necessary IA for inclusion of the present incumbents holding the state post. Full stop. Para. List after 4 weeks to enable the petitioner to take necessary steps. It is needless to state that before filing such application, the present incumbents are to be apprised about the court's order with a request for compliance.
But partly the
Content
order dated 10 law,
10.
10 law, annex to 1.
Yes.
Relevant part is 12.
Page 12.
Yes, sir. Last paragraph. There is
Please read. Please read.
exactly on the matter. The matter is demanded back to the secretary department for verification of the records and after doing the same. Consider the case of the and thereafter the past appropriate order. Check the clearance of the period of the 2 months from the date of the
Not done.
not done. And subsequent fact of the representation that proceed page 30 dated 5/9 is article.
Yes, what do you say, Mr. Das?
So the department the evidence, the student provisions of the 2 class. Therefore, the petitioner opted for
That is on the marriage. What should be done to this petition now?
if I have submitted representation of that is the next an order also not compliant. Let the issue of
Heard. Sri R.C. Das, learned counsel for the petitioner, who, by means of this application, has complained about non-compliance of an order dated 23/8/2022 passed by this court in WPC 1994 of 2021. Full stop. The learned counsel has also drawn the attention of this court to Annexure 2, Roman 2, which is a representation dated 5/9/2022, whereby compliance of the order was requested. So, para issue notice returnable by 4 weeks. Let steps for issuance of notice upon the respondent be taken where is that possibility. Steps within 2 days.
whatever the MR
for the get for the
4 weeks, it's registered post. Minimum 4 weeks.
hello.
They vacating. Hmm?
It's near concept.
Friday. You're afraid of Mr. Goswami.
No, no, no. That's it. In the morning, I have been informed. Change to the junior that change
Go to the gym tomorrow and come prepared. No need of senior.
matter has already been settled by the court. Petitioner has informed it. Thereafter, they want to open the matter again.
Did we hear this matter on the last occasion?
No, no. That is
Oh, that writ appeal was also.
dismissed. And now they want to reopen the matter.
Is there anything to be defended? There is. Okay, we'll let us give him a chance.
My submission will be to get a matter, clear matter on next week or tomorrow, day after tomorrow. Enter matter should be disposed.
No, we'll have the IA decide. Third to SK Goswami Learned Council for the applicant slash respond number
Number
7, who has filed this application for vacation slash modification slash alteration of the order dated 10/8/2022. But on the last occasion, that is 26/5/2023, this court had recorded the submission made on behalf of the applicant that the issue was conclusively decided by this court, including the writ appellate court. The IH Saikia, the learned counsel for the opposite party, public writ petitioner. However, one writ petitioner, opposite party writ petitioner, however, prays for a short accommodation to engage a senior counsel. In the interest of justice, list on Friday. Day after tomorrow. For who is the senior?
Maybe some nice.
You for the IA.
I'm
You filed objection. You filed 9th. You are. Okay. We'll have it on 9th then. On the prayer of. This is item number 60. 3 FZ Mazumdar, Learned Counsel for the applicant. Respond number 7, matter stands adjourned to be listed on 9th of June, next Friday. Under the column, stay vacating. Yes. You have taken steps or not? So this matter has been listed under the column. step, no step. Order, within work, order, no step, comma. What is your name? N.J. Chaudhary. Sri N.J. Chaudhary. Learned counsel appearing on instruction of Sri A.R. Bhuya for the petitioner submit that step upon the response number 4, where is that post to ready, have been taken today. Full stop. Sarah, office to verify and list this case after 4 weeks along with service report. What is the IA? IA 50. IA for what? Stay vacating. Disposed of. IA has been disposed of. The interim has been vacated. Interim order vacated. Yes, next. Mr. Goswami?
Yes, madam.
15 matter. Yes, what is this? You're for the other side. Private respondent. 11. And which department is this? Elementary education. Who's there? To go for whom? You're for 11. 9, 11. And Mr. Kaushik for the department. Who else are there? Who is for 10? J Das. Who is J Das? Gopal Sharma will like that. Gopal Sharma will like that. Can we go for final disposal now? 9. Huh? 9. 11. B. Vermont. M. Islam. You're for 9. 11. Or 10. Huh? J1. Zobadas. 10 is expired. Who's 10? Gauri Kanta. Okay. And his name has been deleted.
Yes, madam.
10, so there is no requirement. 11 we have here. 9 also. 8. President.
Madam, 8 and 9, madam, same is appearing, madam. Madam, there is an order, madam. Is it my friend is appearing from 8 and 9 both, madam. There is an order to that effect, madam.
No, he says that.
President and headmaster.
What he says, Mr. Goi says that in the meantime, the school has been amalgamated.
Madam,
Your contention was based on a feel when it was before the amalgamation. Now it has become one high court, one high school.
It was on 2013, it was provincialized, madam. And madam, in 2017, it was amalgamated. So my case is, madam, prior to amalgamation and even prior to, madam, provincialized.
No, even if we find merits in your case, what relief can you grant? Can we grant?
Madam, what if I go from the court, madam? Since, madam,
first it was recognized. Then financial assistance was granted. Though I was I was senior financial assistance was not given. I preferred representation. That was not they have not done anything to that. Subsequently,
Sir, can we grant any effective relief to you today
yes,
after the development?
yes.
What kind of relief can we grant?
I am challenging his province.
Whose?
Referendum number.
The Islam.
No, yes.
If you want to go ahead, we can go ahead. But it's difficult.
My
15 method is go ahead.
or also want to take it.
No. All days are good for us. 15 method. Yes, 4307. One moment. Modern. Mr. Gogoi for? I'm Islam for? Yes, please. You're challenging what? Provincialization of R11.
Yes, as well as subsequently, I came to know that when all this development were going on, they have dismissed me from service, and they had admitted the fact that there is no notice start on. Without giving any notice, then I admitted position.
Who has dismissed?
Lordship may kindly come to page number 96.
90?
96. It's an affidavit, madam.
Yes,
Yes, madam. Madam, this is the report.
Is it a vernacular?
Yes, madam. Yes, madam. Here's the madam. Yes, madam. 93, madam. This madam, press the copy, madam. It is a report by the Block Elementary Education Officer, madam.
Yes.
Madam, madam, I start from page 94. Last paragraph at the bottom, madam. The person mentioned at serial number 1 to serial number 5 and serial number 8
rate for staff are included in the provision.
90?
Minor 94
Yes.
last paragraph at the bottom.
Upon
That the person mentioned at serial number 1, 94 minor. Case 94.
it is seen that the name of Madan Talukdar. After that, upon being made an inquiry.
Yes, Madan Rao was discharged as per resolution of the executive committee dated 17/8/2006. Therefore, the headmaster did not send his name to, in any paper submitted at the time of provisionalization. Therefore, it is
No,
obvious that the
no,
name
it's not.
of
It's
the
not
Madan-
there. It's not there. You're reading something else.
Madan. Oh, Madan. Madan, Madan, I'll show it in my.
No, doesn't matter. You start at page 93, isn't it? 18.3.
Madan.
18.3.13, correct?
Yes, Madan.
The type copy. Is it 18.3?
Yes, Madan. Madan, Watson may kindly come to page 56. Madan, be on of my
50?
56, my lord, annex 13.
Yes.
Okay. Malam, this is a letter government of Assam office of the district elementary education officer.
1512.
Yes, ma'am. 1512. Malam, I'm starting from sir. With reference to the subject and the letter number cited above, I have the honor to submit herewith the detailed report in respect of the grievance of Sri Madan Talukdar for non-provincialization of his service against Nonbari Ami School under Bozali Education Block as under. That a hearing was conducted in this regard in presence of SMC President of the school and Sri Madan Talukdar on 4/9/2014. That as per hearing and the statement and other related documents submitted by HM of the Nalbari Ami School, it has been found that Sri Madan Talukdar was appointed in the school in 1990, and accordingly he joined in school on 3/3/1990. That as per inquiry report of DO Bozali, it is found that Sri Madan Talukdar was unauthorized absent in school with effect from January 2006 till the inquiry dated 15/3/2013, as a result of which Sri Madan Talukdar was discharged from his duties by SMC as per resolution number 1 of the executive committee meeting of SMC held on 17/8/2006. But in this regard, no notice was issued to Sri Madan. All these developments were going on, my lord. I was preparing application after application, my lord. And my lord, I was not aware of that I was discharged from the my lord. My lord, I was discharged. My lord, my humble submission is on the case of this paper, this is a my lord wrong matter. Because this is only to my lord deprive me from my lord getting problem. So my lord, my name was.
Yes.
My name was not, my lord, they have shown that I was discharged from service, my lord. So my name was not even sent for probation, for consideration. And my lord, the next para, my lord, that in the meantime, the school has been recommended for provincialization by the PLSC, Borpeta, without recommending the name of Sri Madan Talukdar, as his name was not furnished in the provincialization by the headmaster of Nalbari. It is on the behalf of my lord, number 11, and my lord, with solution, my lord, principal, my lord, headmaster, my lord. I was, my lord, shown to be, my lord, discharged from my duties, and my name was not. My lord, secondly, my lord, here, my lord, it is shown, my lord, that my date of appointment is 1890.
So this line, why is the DLSC Borpeta concerned of an appointment of the year of the district of Nalbari? You read the paragraph which you just read. In the meantime.
That in the meantime, the school has been recommended for provincialization by DLSC, Borpeta.
Why Borpeta? This is in Nalbari.
No, my lord, the name of the school is Nalbari, but it is situated at Borpeta. Probably, my lord, before bifurcation, my lord, it was, my lord, it was established, or something like that. My lord told me
something like that, but this fully situated as water. But name is not. Lordship will find, my lord, this is by district elementary education or education officer.
Okay, maybe correct.
So, my lord, my name was not sent, my lord, and my lord, I was typically, my lord, and my lord, secondly, my lord, why all this, my lord, development was getting to my lord. I was, my lord, I was running to post for putting my name included in my lord, list, my lord, and my lord, before that, my lord, I also tried, my lord, I was, my lord, deprived of the financial assistance, my lord, when the school became eligible for it. Those letters were also I have annexed, my lord. I'll show you a lot of other those letters. But my lord, the moot point here is that they have taken, firstly, my lord, why my name was not recommended, my lord. They have said that my date of joining is 3/5/1990 and his date of joining is 4/5/1990. Whereas, my lord, I have annexed, my lord. Lordship may kindly come to case 36.
36.
36, my lord, annex
36 is not eligible.
my lord, not eligible, my lord. My lord, I will only show the seal, my lord, at the top, my lord.
Hmm.
Nalbari ME School, Pio Helena,
Hmm.
established 1986, my lord. My lord, and my lord, bottom, my lord, Akshay Das, President Secretary, Nalbari ME School, date.
Hmm.
My lord, I have given a typo.
Yes.
Next page, my lord, 36.
Hmm.
My lord, probably not next page, it's on 35. 35, page number 35. This typo. There it is. Office of the Secretary, Nalbari ME School, Nalbari, Pio Helena, District, Kolkata, Assam. Subject appointment letter. Sri Madan Talukar Village. You are hereby appointed under M Resolution 1 dated 10/2/1986 as 80 assistant teacher Nalbari ME School. Therefore, you are requested to join in the post of 80 of the school on or before 10/4/86. You have your service will be purely temporary but likely to be permanent. Akshay Das, President Secretary, 10/2/1980. This is the first letter, my lord. 10 to my lord. Next, my lord. At page 37, my lord.
Yes, what do you say, Mr. Islam?
My lord,
We will come back. His first contention that it was done without notice. Can it be done? Hmm. No, the purpose of 36 only to have the year of the establishment, 1986, is not depending on the contents. Now, what do you say about the with the submission, which is also discernible from this letter at page 56? Hmm? Just a minute, just a minute. 75. What is 75? It's 76. Three, 90. We'll do one thing. We'll have this for another day. Next, maybe next Tuesday or next Thursday. Okay.
This case, my lord, I want to point out one possible time, my lord, as he has shown, my lord.
Well,
This is, my lord,
fix for disposal. Fix for
teacher,
disposal.
my lord, all are, my lord, except, my lord, resonance 7 and resonance 11, all teachers are wanted to what to be right. Only he is capable. And my date of appointment, my lord, as I have, and all other teachers, my lord, whose services are commercialized, my lord, all are
Okay, tell us a hearing date. This matter needs to be examined thoroughly.
like,
No, tell us a day, hearing date.
Monday or
Not Monday,
Tuesday or
Thursday. Heard is G. Goswami counsel for the petition. Whereas the private respondent, whereas the department is represented by Sri Kaushik, and the private respondents are represented by the A. Gogoi, M. Islam, A. Gogoi and M. Islam. This court has also noted that the respondent has been struck off. That the name of the respondent, that the name of the respondent, considering that this writ petition is pending since the year 2015, placed for admission hearing on 6th of June 2023, on which date an endeavor will be made to dispose of the writ. Yes.
Yes, sir. The factor is great for the way is promoted of the some that I think for their students their needs to be different sorry this is on the final stage some time
We'll allow this to be withdrawn with liberty.
they will not
Both three as what have put certain counsels for petitioners. No, 16 matter, those are under consideration. We would not like to prolong this matter. Day after tomorrow. No, we may not go into those aspects of the matter. If you want to withdraw, since there is a consideration, that is only for that purpose.
I will take.
কি করলো? Both three portable, both three as portable and concept for a petitioner. And strictly go with understanding concept, higher education department, submit that there is some development regarding redressing the petition, redressing the grievance of the petition. No, there is some development by which the present petition, present challenge may not be required to be pursued. Full stop. Para. The Bota Court has in fact placed before this court an order dated, a communication dated 21/2/2022 with an appended list which contains the name of the present petitioners who are being considered for their absorption. Full stop. Para. In the interest of justice, comma, the matter is adjourned to be listed listed again on Monday. Have some voted on Monday next. You have this copy?
Sure.
Give the date, please. Huh? Monday.
Okay.
Will you file your affidavit? Hmm. 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 Petitioner's name is there. Madam, in view of such termination, page running 46 is the termination order, which Madam has shown. It is it 12/9/2022? And then it's 50/50. Yes, please. Written to the inspector of schools. Please read. Your name is Naren Chandra Boro. But will the headmaster principal have this jurisdiction to write such a letter in view of the termination? Nothing has been said. Madam has said that it is by the management committee. Continue. Let us again come to your his termination order. Page. Standing on the page 46 again, 12th November 2004. This is a general order, isn't it? Please include his name. Was he served? Now, what is your prayer, madam? What do you want? They are denying that they are you are. No, they are denying that you are working under them. Let the managing committee pay. Where? Page 51. Yes, please read. Something else has been stated. This is by the inspector of schools. He doesn't even refer to any discontinuation order. You obtain instructions on this part. No, on your instruction. Do you have the instructions on this aspect? Number one, the order by which you have terminated the services of all mother teachers 12/11/2004, including that which includes the name of the petitioner and the list. Was it served upon the petitioner? No, was a copy of this order served upon the petitioner? Then how will he come to know? Was the college authority, school authority served? Then how does it take effect? This is the termination, discontinuation order. If this order is not communicated to the petitioner, or in the IS is also saying something else, how does this take effect? What is the law on this bit, on the communication? On the requirement of communication? Appointment is was evidence, but he claims to be working, and that has also been endorsed by the IAS. How do you resolve this matter? Hmm? Of what? That's it. Paragraph. Yes, please. You have a copy? This is with regard to appointment of government advocate and their discontinuation. If this order of yours, dated 12 November 2004, is not communicated, we are on that aspect. And if the petitioner is continuing at by the whose permission? If the petitioner has not got the this letter, it was also marked to the school authorities. Anybody is appearing for a school matter?
No.
School has been served?
Yes.
What is the who's the school petition reference number?
Seven.
Whatever. Seven has been served on 28/8/19. the IS PDC you are representing, aren't you representing? And how is it then different from the? He has shown a recent communication of 2022 in the reply affidavit. You take instructions on this because this page 51 of the IS. Yes, how could he write this?
The director also not the best working where the principal
Hmm? Could not follow you. Have you stated in the affidavit? Where? Page? Your affidavit filed on 9th of May, 2023. You're R5, aren't you? R5.
final let's the inspector of of in the letter to the director for the
Madam, at best, we can hold it if you're held to be entitled to salaries, then the management committee will have to pay. Come to page 44, the second paragraph. As per report of the ISPDC, have you found? Page 44. Madam, your affidavit. Please read this. Full management committee will have to pay. We can hold that at best. Cannot put the burden on somebody who has discontinued your service.
not target of the target
What is this order then? 12th of November 2024, 2004.
but that was not heard
That is it. They have clarified that management is allowing you. How can
not aware
you say it is marked to all the schools? At best, it will be a disputed questions of fact. You are something saying something else, is saying something else.
either I have filed an external application later was whether this set of the director where stated that the subject side subject there that the goal for adjustment of the LCA. It is the second course of lesser during LCA that worthwhile to be mentioned that working under Burma Institute was from
Where are you reading? Page
A6, Annex 3, additional officer filed by the petitioner, 15,
Annexus 3,
Annex 3,
addi- additional affidavit.
was adjusted against
Just a minute, just a minute,
again post office.
just a minute. Yes, please read. Page 6 and Annexus 3.
Yes.
Yes, please read.
With reference to the subject cited above, I have the honor to submit here the application of Noreen from the board for adjustment of FTA against the second post of Chief Investor Deals FTA share. Brought forth to be mentioned here that it has been working honorably in Boroma Harbor in 1997. We did and it has been to be adjusted against the second post. Others has filed a petition so and so in the honorable high court regarding the matter, so I take time to the newspaper of the matter.
You have been working honorarily.
Yes. As he is service section,
7878 is the 7878 is the present petition.
yes, ma'am.
Where is the admission? Is it an admission? You have paid for adjustment as an LDA. There is a recommendation, but at the same time, it has been stated that you are working on an honorary basis. Working as what? On honorary basis. You are relying upon this document.
He is appointed as a lower division by the council or constrained in the case of other of the appointed. Those are the purpose and the appointment of the fully knowing that the post
If you continue on your own, in spite of the termination, without salaries for more than a decade, you are not getting the salaries. When did you come to the court? When? After how many years? Sorry.
as I am continuing my
You continue. We are not touching your respect of continuation on honorary basis, but will not recognize any right. If you say that you are not aware of the termination order of 2006, you are not getting salaries continuously, you come after 10 years.
I have approached the authority.
We are not concerned about approaching the authorities. You approach the authorities for 10 years, continuous. Is it a reasonable plea, a ground? Heard. I must A. Buzarburu, Senate Counsel for the petitioner. Also heard. MS R.B. Bora, Standing Counsel, BTC. Para. Considering the subject matter and also the fact that pleadings have been exchanged and the state petition is pending since the year 2017, the same is taken up for disposal at the admission stage. The facts projected is that the petition has been filed for a direction to regularize the service of the petitioner as LDA in Boroma Higher Secondary School, which he claims to have been working for almost 20 years, and also for release of the arrears salaries since April 2006. Full stop. Para. The petitioner claims to have been appointed as an LDA on 15/12/1997 by the Inspector of Schools, Common Albury, pursuant to a letter dated 9/12/1996 by the Joint Secretary BTC, and he was posted at the Baroma Higher Secondary School on a fixed pay of rupees 1,200 per month. Subsequently, on 30/12/2002, the Inspector of School, Nalbari, had passed an order allowing the petitioner to draw regular scale of pay against a vacant post caused by the retirement of one Moni Ramdas, UDA. Also, subsequently, on 6/3/2003, another order was issued by the Inspector of Schools, Nalbari, whereby the petitioner was allowed to work as LDA, which he continued till March 2006. However, it is the case of the petitioner that from April 2006, his salaries were stopped without any reason. The petitioner claims to have approached the respondent authorities on a number of occasions, and nothing has been done. The petitioner further claims that resolutions were adopted by the school managing committee on 16/8/2017 and 20/10/2017 for appointment of the petitioner in the vacant post of UDA, which were existing, and the proposal was also forwarded to the Director of Education, BTC. However, nothing has been done, and therefore the present petition has been filed. MS Huzarvuru, the learned counsel for the petitioner, has submitted that the petitioner is continuing in his service, and therefore the prayer for regularization of his service is justified, more so when the school managing committee had taken resolution to that effect. He further submits that by referring to the pleadings and the documents submitted, more specifically, more particularly, a letter dated 26 March 2018, it is the submission of the learned counsel that by the said letter, the Inspector of Schools, Paksa District Circle, had written to the Director of Education, BTC, forwarding the case of the petitioner for adjustment. Sarah. On the other hand, the MSRB Board of the Learned Standing Council, by referring to the affidavit in opposition filed by the BTC on 10/9/2019, has submitted that a vital aspect of the matter has not been highlighted in the petition or the additional pleadings. by referring to a communication dated 12/11/2004, which has been annexed to the additional affidavit submitted, filed by the respondent number 5 on 9/5/2023, comma, the Learned Standing Council submits that by that a decision was taken to terminate the services of all mother teachers, comma, LP school, LP English school, comma, LD assistants in ME schools, comma, Malis, within bracket gardeners in high school, comma, assistant teacher in high school, and counselors teachers for which no post has been sanctioned by the government of Assam. Full stop. The Learned Standing Council accordingly submits that since the services of the petitioner were terminated, comma, the authorities cannot be saddled with the responsibility to pay the salaries after the said date. Para, replying, rejoining MS Buzarburi has, however, replied that the said order dated 12/11/2004 was never served upon the petition, and he was therefore not aware of the termination order. He further adds that the fact that the petitioner was allowed to continue in his service would make it apparent. However, she further adds that on the other hand, the petitioner was allowed to continue in his service, which he claimed to be even today. The rival contentions made by the learned counsel for the party have been duly considered, and the materials placed before this court have been examined. The prayer made in the repetition reads as follows, prayer page 8. The relief pertains to regularizing the service of the petitioner as LDA in the Poroma Higher Secondary School and release of the arrear salaries since April 2006. Full stop. The BTC authorities has put on record an order dated 12/10/2004, whereby a decision was taken to terminate all appointments, including that of the petitioner, which were not, which were made in post, which were not sanctioned, which were made in post, not sanctioned by the government of Assam. Full stop. Even assuming that, even assuming for the argument's sake that the contention of the petitioner that copy of the aforesaid order was not known to him, comma, what intrigues this court is the long delay of more than a decade in approaching this court. Full stop. The same issue can also be examined by the contents of the communication dated 26/3/2018 issued by the Inspector of School, BDC, wherein it has been stated that the petitioner has been discharging his service in the school on honorary basis. Full stop. Para. It is a settled law that in a provincial school, the management committee does not have any jurisdiction to make any substantial appointment. And in the instant case, the petitioner claims to have been inducted in the service of the school by such a resolution. No. No. And in the instant case, the petitioner claims to have been appointed in the same school on 15/12/1997 as per an order by the IS Nalbari. However, as would transpire from the communication dated 12/11/2004, which are supported by the reading that such posts were not sanctioned by the government of Assam. Under those facts and circumstances, this court is not inclined to accede to the prayers made in the writ petition. Accordingly, according to this writ petition, is devoid of any merit. However, regarding the payment of salaries, if the petitioner is actually serving as permitted by the school management committee, it is up to the committee to arrange for the fund to make payment to the petitioner after verifying as to whether he had actually been rendering his service. Preparation account disposal.
Like,
Any other names appearing?
no, not about. And 5 days.
So we grant some more time. If none appears, then we'll dismiss it. We M. the Senate Council for the petitioners submit that though there were 3 counsel on record, the brief has been taken away by the client recently. Para, because this does not reflect names of any other counsel. In the interest of justice, matters can adjourn by a week to enable the petitioners to engage any new counsel if so advised. One last matter. Yes.
Determine if it is the last order.
Yes. There is some cabinet decision There is no conflict that means. Pursuant to the order dated 17/5/2023, Sri K. Gogoi, Training Council, Higher Education Department, submit that instructions have been obtained. He further submits that there is no conflict of the stand taken in the affidavit in opposition by the Director of Higher Education with the decision of the with the cabinet decision dated 19/3/2012. He submits that the decisions are on different issues. One connecting assistant professor, and the other the decision of the cabinet. The court has noticed that there was a conflict. You said there is no conflict. Okay, there is a distinction. Are different issues. One connecting, one in connection with the services rendered by professors, and the other in connection with services of associate and assistant professor. Why didn't you file an affidavit? They should be aware. Okay. And this fact was already explained in the affidavit in opposition. We'll have this resolved whenever 19 matter. Since pleadings are complete, the matter will be discussed for admission hearing when? On 13th June, Tuesday. Okay, Mr. Rest, time will not permit. Any matters where interim order is still today? Yes. He'll give this. Any matter where interim order is still today? Interim order. Interim order only. Only matters where interim order is still today. The press matter contempt item 3 on Friday. He'll give this. Press matter don't collect it. Friday. Item number 62. Interim order is there, 37. Possibility of time did not permit the matter to be taken up. Interim order. Any more matter where interim order is still 62. One heading matter. This matter 6 on 8. We have said the dates will be given by court master where matters interim order needs to be extended. Interim order is there. If interim order is not there, why are you mentioning now?